Hello, everyone, and welcome back to the judicial process. This class, we are moving into section 2 of the text. Specifically, we are looking at prosecutors, right, in the courtroom work group. And we're going to see is the courtroom work group consists not only of prosecutors, but of judges, defense attorneys, and sometimes other actors. So that being said, let's jump into prosecutors. So we look at a history of prosecutors. The United States system developed over time, and it largely came from European sources. So basically, back in the 1600s to the 1700s, both in England and America, the United States colonies, or colonies at that time, I should say, engaged in what was called a practice of private prosecution, right? Private prosecution. In other words, what happened is a victim or a family member of the victim would essentially arrest and bring the offender or would-be offender to court for the court to adjudicate the matter. So it really resembled a civil lawsuit, right? And civil lawsuits today is a private person suing another private person, usually seeking some kind of monetary damages. Here, it was the criminal aspect, right? So it still had that kind of civil feel to it, but it was with criminal penalties as the end result. As a result, there was no designated public prosecutor at this national level, right? Or at the local level in the colonies, or really even in England. So we look at the history of prosecutors again, and we're looking at the Attorney General of England. So Attorney General of England was kind of a chief prosecutor. It's really hard to describe his role, but basically the Attorney General of England could initiate prosecutions. So the government, he works for the government, could initiate prosecutions, but only did so in cases of special importance to the crown, right? So in cases where the crown, the government, had a vested interest. So this often would be treason, sedition, etc., things that posed a danger to the crown. Now, that being said, in order to control excess private prosecutions, since that was the majority, right? The Attorney General only came in if it was important to the crown. So private prosecutions were the kind of the mainstay of the day. Now, to control the excess of private prosecutions, the Attorney General would often file what's called a writ of nolo prosequi. Basically, this is a writ of no prosecution. And what this did is it signaled the Attorney General's intent to not prosecute an individual for a specific crime. Now, this could be thought of as a deterrent for private prosecutions, because if the Attorney General says they're not going to do anything, then, or they don't see that there's anything there that's worth prosecuting, it's going to be difficult for a private individual to justify this. So that was kind of the goal, right? And we kind of transition back into the American colonies. So the American colonies initially followed this system by appointing an attorney general for each colony, right? So Virginia was actually the first colony to appoint an attorney general in 1643. And they did engage in, and sometimes would engage in prosecutions. A lot of times they just filed a writ of nolo prosequi, and that would be it. Now, the private prosecution system, however, really proved to be unsustainable for the colonies, right? And very much a far cry from the modern conceptions of justice. And we're going to take a look and kind of see, what does that mean? Right? So when we're thinking about this kind of far removed from the modern conceptions of justice, it did look like a civil lawsuit, right? There wasn't a professional prosecutor. The prosecutor wasn't elected. There wasn't people say in it, right? Everything kind of happened in private, and it was just unsustainable, and really rarely resulted in what you could consider a just result. So that being said, in 1704, Connecticut became the first colony to adopt a system of public prosecutions, in which they created county courts and county prosecutors. Now, this actually laid the foundation for most states in the United States in terms of how they prosecute cases today, right? But until 1704, we did not have, for the most part, a public prosecutor, right? 1704, that changes. Now, we do wait almost 100 years. So following the revolution, most public prosecutors were appointed rather than elected, right? And they maintained very little power, especially at what you would consider under in the new United States. At the federal level, federal prosecutors virtually had almost no power whatsoever. Instead, it was relegated to county prosecutors, and the county prosecutors were appointed. They might be appointed by the legislature or the governor. We're going to see there's different ways that they can get appointed. Now, it wasn't until the start of the Civil War in 1861 that Congress gave the Attorney General of the United States, right? So we still took that name from England, the Attorney General of the United States, control of the United States attorneys, right? So basically, each state had a United States attorney who worked on behalf of the federal government, prosecuting federal crimes and dealing with federal issues. So basically, before this period in time, the United States attorneys could kind of generally do whatever they want. So when the Attorney General gets control, it starts to lay the foundation for the later United States Department of Justice, something that you usually hear referred to as the DOJ, right? And what it does is it lays the foundation for the modern prosecutorial system. So at the state level, right, prosecuting attorneys enjoyed a lot of power. Again, they were typically appointed by the governor of the state or judges of the county court. But this went fine and dandy until about 1820. In 1820, there was a push for increased democratization, including a push for elections, right? The idea was that only people, if the governor appointed somebody, or if the state legislature appointed somebody, or if judges appointed somebody, there was going to be maybe some conflict of interests, there might be some quid pro quo, there might be political favors, right? The citizens didn't have control over the justice system. And to many, that was wrong, because that was kind of the whole point of the United States. So we see this push for democratization. Now, as a result, in 1821, the first prosecutor is elected, and they're elected in Ohio. And then 1 year later, Mississippi becomes the first state to include a constitutional provision providing for the election of prosecutors, right? So you have a northern state, a southern state. We tend to joke and say that southern states are behind, but here in Mississippi, we led the trend. I mean, they were like, okay, we need to increase public control over prosecutions, over the criminal courts, etc. So we're going to make it a part of our Constitution that the prosecutors have to be elected. And that really started the first domino in a chain of dominoes, to the point that by 1859, virtually every local, when we say local, we're meaning like kind of county level prosecutor, was elected. Right? And so really by the 1900s, right, so about 40 years or so, in the prosecutor being in this role, the prosecutor becomes the most powerful governor or most powerful figure with respect to criminal law, right? So the prosecutor can decide whether to bring charges, whether not to bring charges, what charges to bring, pleas, plea deals, plea offers, right? They really control most of, and they seem to be really one of the most powerful, if not the most powerful actor under the criminal law. Right, that started in the early 1900s and is very much true, even increasingly true to this day. So if we kind of jump ahead to today, prosecutors in federal courts, they are conducted by members of the DOJ, so the Department of Justice. Right, so the Department of Justice represents the government in all matters not delegated to other agencies. Right, so kind of the thought process behind here is, if we think about the criminal matters, we just kind of take a criminal context to this. The DOJ, when you see a court case, right, it will say something like United States versus Smith, if it's at the federal level. If it's at the state level, it might say New York versus Jones, right? Before, it was just a private party versus a private party. And it was kind of a hard distinction between criminal and civil. Now we have this really, really well-defined distinction, right? So the United States, when they are pursuing criminal charges against someone, the DOJ is responsible for pursuing that prosecution. Right, so if we think about the mission of the DOJ, the mission of the DOJ is to, quote, enforce the law and defend the interests of the United States according to the law, to ensure public safety against threats, foreign and domestic, to provide federal leadership in preventing and controlling crime, to seek just punishment for those guilty of unlawful behavior, and to ensure fair and impartial administration of justice for all Americans. Right, so it takes a very broad language, but the language suggests that fairness and equality kind of prevail, right? That's the mission of the DOJ. Now, is that how things play out? No, not necessarily. But again, it's a good starting point. Now, it's also very, very broad, right? Defend the interests of the United States according to the law. Well, that's really broad. To ensure public safety against threats, foreign and domestic, also very broad. Right? To provide federal leadership in preventing and controlling crime, very, very broad. It doesn't get into specifics. Instead, it gives us this really broad overview, which is the whole point of a mission statement. So as a result of this broad mandate, the Department of Justice, the DOJ, has become, quote, the world's largest law office. And I say that because it has numerous divisions and subdivisions, right? So we're going to take a look at an org chart here in a second, and you're going to see just how this thing is broken down, and how specific and how tailored some agencies or some attorney general's offices are. So this is the org chart, right? So at the very top of the chart, you have the Attorney General of the United States. Right? Attorney General of the United States very rarely, if ever, goes to court. Same is true for the Deputy Attorney General. However, under them, there's where we have a lot of trial work and even more so law enforcement work. Right? So if you look 1, 2, 3, 4, 5 to 6 columns over. So really the starting with Federal Bureau of Investigation, the criminal division, going down, that's where most criminal actions come from, right? So there's a criminal division of the DOJ that reports to the Deputy Attorney General. Within the criminal division, you have the Federal Bureau of Investigation, so the FBI belongs to the DOJ. The Drug Enforcement Administration, the DEA, belongs to the DOJ. The Bureau of Prisons, BOP, belongs to the DOJ. The U.S. Marshal Service, the Marshals, belong to the DOJ. There's Interpol, which is an international organization. It belongs to the DOJ. Then we have alcohol, tobacco, and firearms, also belonging to the DOJ. And probably most importantly, we have U.S. attorneys. Now, what's really interesting here is everything I just said, with the exception of the U.S. attorneys, they are considered kind of like the front lines of law enforcement, right? So the FBI makes arrests, the DEA makes arrests, Marshal Service makes arrests, the Bureau of Prisons, they house prisoners, the ATF, they deal with and make arrests. The U.S. Attorney doesn't, but the U.S. Attorney does take the cases that these agencies put together and represents the United States in those proceedings against the individuals or the suspects that become defendants, right? And so there's the criminal division, and it goes up and it reports to the Deputy Attorney General, who then reports to the Office of the Attorney General. Now, if we kind of take a step and look at some other areas, we have the Office of the Pardon Attorney, the National Security Division, the Officer of the Inspector General, the U.S. Parole Commission, right? These kind of all relate to the criminal division, but they are kind of their own separate entities. Then on the left side, we really have the civil stuff, right? So we have the Civil Rights Division, the Civil Division, we have the Antitrust Division, the Environmental National Resources Division, the Tax Division, the Foreign Claims Settlement Division, Office of Violence Against Women, and it goes on and on and on. So really we have, again, there's this kind of criminal focus and justice focus to it, but it gets very specialized and there are so many subcomponents, all right? Even think for a second, right, this is the DOJ. The DOJ, you have the criminal division. Underneath the criminal division, you have the FBI. Think about the FBI. The FBI has several different units, right? They have they have intelligence, they have drugs, they have cybercrime, they have, you name it. And so even within each of these little boxes, there is a whole massive structure at play. Right, so when you think about everything and everyone that falls under these categories, this is what makes the Attorney General's office, the DOJ, the largest law firm in the world. So let's talk about the Attorney General. So the Attorney General of the United States is appointed by the President with the advice and consent of the Senate. The Attorney General serves as the head of the DOJ and is a member of the President's cabinet. As a member of the President's cabinet, he or she will generally echo the policy priorities of the President. So whatever the President believes is the most pressing issues that need to be dealt with in a criminal manner, that's generally what the Attorney General is going to do. They don't have to. They don't have to. But that's kind of the policy that they're going to set and say, we're going to focus on cyber crimes, right? This is the growing threat. This is what the President wants us to focus on. This is what we're going to try and prosecute. And so you're going to see a shift in the DOJ to kind of focus on these crimes. They won't focus on these crimes exclusively, but they will dive deeper than they had historically. Now, he's a member of the President's cabinet, and she's also the chief law enforcement officer in the United States. All right, so when we think like law enforcement, we generally think like chief law enforcement would be the head of the FBI or something like that. No, chief law enforcement officer in the United States is the Attorney General. As we're going to see at county level or even state level, the chief law enforcement officer in the state is the Attorney General of the state. The chief law enforcement officer in the county is not the sheriff. It's the prosecutor. In fact, a lot of my friends who went into prosecution, and at least in Massachusetts, if you're a prosecutor, you carry a badge. Now, you don't wear it, you don't have a uniform and whatnot, but you do carry a badge. So they are members of law enforcement, even though they are attorneys. Now, as chief law enforcement officer, the U.S. Attorney General very rarely, however, appears in court. They really are responsible for administration. They're responsible for in responding to the president, and they don't act as attorney for the president. So what we saw under the Trump administration was a really weird thing that hasn't really happened before, and President Biden has echoed it's not going to happen under his administration. The Attorney General is not the attorney of the president. right? And that's one thing that we really have to keep in mind. The Attorney General is not the attorney of the president. The president has White House counsel. The president has presidential counsel. They have their own staff of attorneys. Instead, the Attorney General is the attorney for the United States of America. And sometimes this means the Attorney General has to get involved in prosecutions that may implicate the president or may implicate the same president, or they can't usually be indicted, but even past, once a president leaves office, they can initiate investigations, all of those things. So it's really, really, really important to keep in mind, the Attorney General is not the attorney for the president. The Attorney General is the attorney for the United States of America. So if you want to see an example of policy setting, take a look at box 2.4.2 on pages 127 and 128 of your book. In this, you have a memo to the U.S. attorneys detailing what the Attorney General wants them to focus on in terms of prosecutions and how they should respond to certain things. It's really an interesting way. It's a memo, but it's an interesting way to basically say to the state's attorneys that this is our focus. You're going to do this, you're going to do that, you're going to do this. You can still do the other stuff, but you need to focus on this, or we need to be very careful about this. We need to think about this, right? So again, it's not necessarily a direct command, but it is taken as such. Now, that being said, the Attorney General's office, as we saw, is decentralized into many different divisions, and for our purposes, definitely the criminal division. Now, when we think about the United States Attorney General, of particular importance and falling again under the criminal division of the DOJ, as I said before, is the United States Attorney. So the United States Attorney is the chief law enforcement officer and prosecutor in their district. So if you recall the map that we looked at in a previous class that had the United States broken up, and you could see lines running through them, and each line was a district. Well, to this end, there are 93 United States attorneys working to enforce both civil and criminal federal law throughout 94 districts. One thing to kind of keep in mind here is the United States Attorney isn't, yes, they are a prosecutor, but they're not just responsible for criminal actions, they're responsible for civil actions. Right, so if you file a lawsuit against the United States, right, the United States government, you decide to file a lawsuit. So you go to federal court to file the lawsuit. The U.S. attorney for that district, theoretically, is the chief person who is responsible for defending the government in that lawsuit. Now, they are probably going to appoint somebody else to do it, right? Because again, they have much more of an administrative role than anything else. That being said, each U.S. attorney, so for each district, each U.S. attorney is appointed by and serves at the pleasure of the president with the advice and consent of the Senate. Right, so what this means is the president nominates somebody to be a U.S. attorney in a district. Then the Senate they do an investigation, they have a hearing, and usually for U.S. attorneys, it's very low-key as opposed to judges, especially Supreme Court judges. There's a huge difference there. Generally speaking, the Senate never has a problem. They always just say, yeah, they all vote yes. But it's interesting to note is the U.S. attorney serves at the pleasure of the president. And what that means is the president can at any time, for any reason or no reason, terminate a U.S. attorney, right, and appoint a new one. They serve at the pleasure of the president. And this also means that their job is inherently affected by politics, right? That being said, the workhorse, so the ones who bear the bulk of the day-to-day responsibilities of statutorily imposed duties and prosecutorial duties are assistant United States attorneys. You may hear them referred to as AUSAs, right? So there's over 6,000 of them out there. And basically within the district, you have the U.S. attorney who sits on as the chief law enforcement officer in the district. And then under the U.S. attorney, there are several AUSAs. They're the ones who are actually going to court. They're the ones who are actually prosecuting cases. They're the ones who are defending cases when they need to. Right? So the AUSAs are, they generally specialize, and they're really the ones that you would see in a courtroom, right? You're very rarely going to see the U.S. attorney in a courtroom, unless it's like a very big, huge landmark case. Even then, it's probably going to be an AUSA. So an AUSA is kind of what we think about when we envision in our heads when we think about prosecutors. So let's kind of shift now and look at state prosecutors. So as I said before, each state has an attorney general that serves as the chief law enforcement officer. And their power is actually very limited in criminal matters, right? So the Attorney General of New York doesn't get involved in criminal matters very often. Instead, the vast majority of the day-to-day prosecutions in a state fall upon the more than 2,400 county-level prosecutors across the United States. Right, so most crimes, you're going to be dealing with wherever the crime occurred, you're going to be prosecuted by the county prosecutor of that county. Now, depending on the county, the county prosecutor might be in an administrative role, or the county prosecutor might be in a literal role of they go to court. Now, when we think about the 2,400 county level prosecutors, we also have to think of a very big system, because they have support staff of over 80,000 people. Right? So this includes like paralegals, legal assistants, investigators, etc. Doesn't include police departments or anything like that, but it includes all of that. Now, their budgets range from a mere $5,000 is the lowest in the United States. So it is a tiny county with like 3 people, upwards of $285 million a year to prosecute cases. So this is just a staggering number, right? We're talking, this is large cities. We're talking like New York City, LA, I mean, big, big, big cities, where even though they're broken into counties, I mean, the city will have their own prosecutors, but we're talking counties at this point. Consider New York City's broken basically into like 5 counties. Each one of those counties is going to have 285 million, billion dollars in funds to prosecute cases. Because prosecutions cost money, right? Not only do you have to pay the salary of the prosecutor and the prosecutor support staff, you also have to pay investigators, you have to pay for office supplies. I mean, very, very basic stuff. It can become very costly, especially at larger levels, right? So again, this is where we're talking the $285 million dollars being kind of the top of the chain versus $5,000, right? I mean, it's such a disparity. But what we're going to see is this disparity exists in a very bad way in terms of a defense, right, or defense attorneys. So generally speaking, prosecutors have, to prosecute a case, almost unlimited budgets, right? They have an overall budget, but to prosecute a case, they almost have unlimited budgets. We're going to see that public defenders and defense attorneys do not, right? So there's already a disparity of power when we look at the prosecutor's budget. And when we get into defense attorneys, we're going to see just how big of a difference there is. And it does raise questions as to whether we have an equal access to justice and whether both sides, the state or the United States and the defendant, if they are represented equally, right? And that's a very interesting point. So now we talk about the selection of state prosecutors. Unlike federal prosecutors, state level chief prosecutors are elected, right? So that is with the exception of Alaska, Connecticut, the District of Columbia, and New Jersey. These areas, I'll say states, but the District of Columbia as a federal enclave, operate under an appointment-based system or as member of the state's Attorney General's office. So an appointment-based system is the governor might appoint, or the chief judges may appoint somebody to be the prosecutor, or again, the state attorney general's office might have a branch that is dedicated to prosecutions and represents the state in each different county or each different jurisdiction. So that being said, when we think about the selection of prosecutors being elected, that seems very much like it's in line, and upon first blush it seems like it's very much in keeping with America's democratic values. However, studies suggest that electing prosecutors can be very detrimental to the ends of justice. Specifically, studies have observed some of the following things. First, in election years, prosecutors engage in a decreased amount of plea bargaining, resulting in harsher sentences than those not seeking re-election or facing an uncontested election. Right, so prosecutors, if it's an election year, they're going to want to appear like they are the absolute toughest. Especially if they have an opponent, they are the absolute toughest person on crime. Right, so they will get plea bargains, but they are going to be really staggeringly harsh, or they are going to make sure that they give harsh recommendations, and they're going to prosecute everything. They are going to work overtime in election years. In non-election years, then we have more fair plea bargains, more equality in plea bargaining, etc. Now, that being said, this isn't necessarily a widespread problem because the vast majority of prosecutors in the United States at the county level run unopposed. So it gives citizens very little choice, right? Which is a problem in and of itself. If you just have one person on the ballot, that person gets de facto elected, you don't get a choice and to say, this is what I care about, or these are the policy issues that I think we should focus on and prosecute, right? So maybe you have a prosecutor who's renowned for just being tough on drugs, and as we kind of see America starts to embrace the use of soft drugs and like marijuana and the legalization, you may want a prosecutor who says, you know what, I'm not going to waste your taxpayer dollars on these like really not serious crimes. Do you want me to spend your money prosecuting people for possession of marijuana, or would you rather me spend your money prosecuting people for murder? Right, so it doesn't really give us a whole lot of say when it comes to priorities that the government sets, or that the county prosecutor sets, and what types of cases they go after and how hard they go after them, etc. So we don't have very much choice. Those that do run opposed always adopt that slogan, get tough on crime, right? I'm tough on crime. We've got to get more tough on crime. They want the citizens of the county to think that crime is out of control in the county, and that they are the only person that is equipped enough to deal with the issues in the county, issues in the criminal aspects of that. So that's kind of where we're talking about selection of prosecutors is where we're at today. There's also, when we think about the selection of prosecutors, especially in the electoral system, it's resulted in a gendered and racial inequality. Right, so in 2015, 88% of lawyers were white. 95% of the country's elected prosecutors were white. 36% of lawyers are women. 83% of prosecutors are men. Now, what's most shocking is only 1% of prosecutors in the United States are women of color. So is there fairness? Is there equality here? It doesn't seem like it. Now, there's everything from systemic sexism to systemic racism. There's all kinds of like psychological factors. There's all kinds of factors that go into play. So you can't just blame the electorate. But this is a problem, right? Because if we just have white men prosecuting cases, then that's the white man's agenda, and that's what they're going to follow, right? Whereas maybe a woman of color might see some crimes differently, might see the situation differently, right? That's the great thing about diversity. It lets you see things differently from different aspects, from different points of view, and lets you change your own to have a more informed point of view. So it's a problem, right? If we kind of move on and talk about another type of problem, this is called, we're going to talk about prosecutorial duties and discretion. So one of the greatest tools that a prosecutor possesses is their what's called prosecutorial discretion, right? And it's a tool that basically remains unchecked. So the prosecutor can prosecute cases or not prosecute cases. It's entirely up to them, right? So you've probably all watched on TV and crime shows, and at some point in one of the crime shows, they'll say, the victim doesn't want to press charges. It's not up to the victim. Like the victim, like the prosecutor might give them some okay, acknowledge that fact, and maybe give it deference, and maybe that might go into their calculation as to whether to prosecute or not. But if a victim doesn't want to prosecute, it's not up to the victim. It's up to the prosecutor. Because in the United States, victims are technically witnesses, right? When you commit an offense, you actually commit the offense against the state, if it's a state level offense, or the United States. You don't commit it against a person. So the victim doesn't really have a whole lot of say, right? And instead, the prosecutor does. The prosecutor has a lot of discretion in terms of who they'll prosecute, what they'll prosecute, things like that. Now, this has obviously historically resulted in some big bias issues, right? So specifically like selective prosecution. And selective prosecution, basically you target certain people for crimes that if somebody else, maybe of a different race, committed, you wouldn't prosecute, right? So this would be, let's say, simple possession of marijuana. Selective prosecution would be, I'm not prosecuting the white people for possession of marijuana, but I'm prosecuting the black people for marijuana. And usually it has to be even further than that. It has to be, look, you're prosecuting me, but you didn't prosecute the exact same person in the exact same situation. You're just trying to go after me, right? So that's an abuse of power, is if you try to use your prosecutorial duties to attack certain people, groups of people, or specific individuals. Now, to kind of combat this, many prosecutors' offices have guidelines that try to curtail discretion, and they set up prosecutorials, the law enforcement priorities. So, for instance, one example is the United States Attorney Manual. So, the United States attorneys all have a manual, and one of the things that it does and has for several years is it's made enforcing healthcare fraud a top priority. Now, that being said, the problem with these guidelines is they're guidelines. They're not necessarily mandatory, and they are subject to the will of whoever is in charge of enforcing them, and are enforceable only as the department chooses, right? So let's say that you're not supposed to prosecute a simple possession of marijuana case. We're not going to waste our funds. And you, as an assistant prosecutor, prosecute a marijuana case. We could discipline you. We could go after you. We could do a lot of things. But we're not going to, for the most part, right? So even though we have guides in place, we generally follow them. I will give you that. We generally follow them. But when we don't, there's no resulting penalties usually. And obviously, that is a problem. So we talked a little bit more about abuses of discretion. All attorneys, including prosecutors, are bound by what's called the rules of professional conduct. So the rules of professional conduct are there's like this, it's like the model penal code. There's a kind of the ABA's big guidelines, right, as to rules of prosecutorial conduct or professional conduct, and each state's bar adopts their own rules of professional conduct that dictates what lawyers can do, can't do, etc. Now, most states kind of fall in line with the ABA's guidelines, but they can have their own. But for the most part, they're fairly uniform. Right? And what this allows bar associations to do is it allows prosecutors, like if they abuse their discretion, like it generally speaking, they can weasel out of being in violation of the rules. So the rules really dictate, like, you have to have a trust account for your clients, right? So you put money in this separate account and you only withdraw the money as you use it, type thing. Prosecutors can abuse their individual discretion via overcharging. So overcharging is where you slam somebody with every charge you possibly can think of for some crime, right? So let's say you find I don't know, ammunition, like you just find one bullet in the back of in the trunk of a car of a felon, which, yep, granted, is illegal. So you charge them with being felon in possession of ammunition. You charge them with, because they kind of looked like maybe they had a couple drinks, but they didn't. We didn't really go that far to investigate that. You charge them with drunk driving. You charge them with maybe attempt or at least beginning premeditation of some kind of crime. Like if they got pulled over at a gas station parking lot, you say that maybe you were going to attempt to rob the gas station, with your bullet, even though there was no gun. We can just find things and we can kind of create scenarios. And so we slam somebody. So we're like, you're felon in possession of a handgun or gun, or you were attempted robbery, you were drunk driving, your plates were expired, and they charge you with all this stuff. The idea is the more that they charge you with, the more you're going to likely accept a plea deal, and the more likely you are going to accept a plea deal that has a severe penalty. Right? So if they just charge you with being a felon in possession of ammunition for one bullet in the back of your car, they're not going to waste their time. Most of them aren't. But if they do, right? Like, you're just going to have a general plea bargain of like, this wasn't really that big of a deal. It might have just been an accident. There's all kinds of, it's not that big of a deal. So you're probably just going to get like continued probation or something like that. Right? But if we overcharge you and we charge you with everything we possibly can, which is technically legal and technically follows the rules of professional conduct, but it's bad form. It's very much unethical. If you're doing it just to get that person to plead guilty to a higher crime or a higher sentence, whatever it takes. We talked about selective prosecution. Prosecutors do abuse their discretion in regards to that. And prosecutors can abuse their discretion as to horse trading. So horse trading often involves public defenders or private attorneys, and they'll basically say, okay, we have two cases, right? Got one case, let's say they're both simple possession. Got one case that is a 18-year-old kid, had possession of marijuana. He was on his way to a party, right? And he gets pulled over, they smell the marijuana, and they find just a joint in his pocket. And then there's another case that you have, again, as a public defender, and it's a simple possession case. And this one is a 35-year-old man who has been charged several times with the possession of marijuana and whatnot. So like they've gone from kind of like a misdemeanor offense to a felony offense, right? So it's more severe, even though it's the same thing. So what happens in horse trading is the prosecutor says, tell you what, if your guy, the 35-year-old, if he takes a harsher plea deal, if he takes a harsher sentence, I'll drop the charges against that kid or lower the charges or make sure that kid like doesn't have a record. That's horse trading, right? That's like, you give me this, I give you this. That's that quid pro quo. That's an abuse of discretion. That does happen. And that's where you kind of have to trust your attorney, because you don't know what they're saying in private to the prosecutor usually. So yeah, horse trading is a big deal. It's very unethical. I know a lot of like defense attorneys' offices, public defense offices, they will fire you in a heartbeat. They will bring complaints before the bar in a heartbeat. Prosecutors' offices a little bit different, again, because they're kind of in charge of enforcing the law and being ethical. Not to say this happens all the time or is a regular occurrence, but it definitely does occur. And it's something you need to be aware of, especially when you consider that 90 to 95% of cases end with a plea bargain, right? And each guilty plea is counted as a win for the prosecutor. And wins are how prosecutors get promoted in appointment-based systems or reelected in election-based systems. So you take a look at the hypothetical on box 2.44 when you want to. It gives you a decent hypothetical. But I mean, when you think about this, right? Prosecutors have all the reason in the world to abuse their discretion, right? They have every reason in the world to engage in selective prosecution, overcharging, horse trading, because that's how the case is going to end in plea bargain, right? And the more severe the outcome, the better it is for the prosecutor, especially in election years. Now, that being said, prosecutors are prohibited from engaging in selective prosecution, again, in which the decision to prosecute must, one, not be deliberately based upon unjustifiable standards such as race, religion, or other arbitrary classification. So basically, I can't prosecute, if I decide to prosecute all Black people for possession of marijuana, but not all white people for possession of marijuana, I've hit the first prong. Right? I can't do that. That is a prohibition. The defendant must not be singled out for prosecution, while others in similar situations committing the same acts have not. Right. So this is, we're going after one person who's in this, who has a joint in their pocket. But we let the mayor go last week who had a joint in his pocket, but we're after this guy. We don't like him. He posted mean things about the police on social media. That's what you're prohibited from. That's selective prosecution that you are prohibited from. Right. So take a look at box 2.4.5. It's United States versus Armstrong. It's a 1996 case, really dealing with this and really showing that, yes, there's this prohibition, but it is an insanely high bar. That being said, victim services is something that most offices, prosecutors have, and a lot of them have to have it by law. So each United States Attorney's Office has a victim's witness program. So federal law guarantees, even though the victim is not technically the victim, federal law guarantees each victim the following rights. They have the right to be reasonably protected from the accused. They have the right to reasonable, accurate, and timely notice of any public court proceedings or parole proceedings involving the crime or any release or escape of the accused. They have the right to not be excluded from such public court proceedings unless the court determines that testimony by the victim would be materially altered if the victim heard the other testimony at the proceeding. They also have the right to be reasonably heard at any public proceeding in the district court involving release, pleas, sentencing, and paroles. So this is where they give what's called a victim impact statement. They have the reasonable right to confer with attorneys for the government in the case. They have the right to full and timely restitution as provided in law. They have the right to proceedings free from unreasonable delay. They have the right to be treated with fairness and with respect for the victim's dignity and privacy. Right, so there's quite a bit here. They also have the right to be informed in a timely manner of any plea bargain or deferred prosecution agreement. right? So we give victims a lot of leeway and give them a lot of rights. We don't necessarily enforce it, right? It's kind of an afterthought for a lot of prosecutors because they're so involved in the case. They'll make the plea and then they'll be like, oh, yeah, I got to tell the victim, hey, victim, this is the plea that we're making. And the victim can be outraged and be like, no, absolutely not. That's terrible. I'm not getting what I want. But again, it's not up to the victim. So like they get notified and they can talk, but it's not up to them, right? They just get a right to talk and a right to notice. Like that's it. That being said, I mean, it is a step forward from where we have been. And many states have followed the federal government's lead and have created their own what's called Crime Victims Bill of Rights, under which the prosecutor bears certain burdens in favor of crime victims, very similar to those that we just discussed. So if you look at box 2.4.6 or box 2.4.7, there are sample real victims Bill of Rights from a few states. That being said, next class, we are going to shift our focus and we are going to look at defense attorneys, look at the other side. What do they do? And as always, if you have any questions, comments, concerns, please email me, contact me, whatever you need to do to get a hold of me, and I'm more than happy to talk to you.